Artificial Intelligence, Law and Justice, Session 15, Machine Learning and Copyright, and Overview. We'll do a recap of the last session, that is the first session on AI and copyright. In the last session, we gave a quick overview of the issues in AI and copyright, and then we also looked at some of the concerns of the creators and artists, and we contextualized them in the broader political economy of copyright, IP, and innovation. In fact, we also made it clear that we should not simply go by the rhetoric or what the people claim to be their safeguard in the interest of this party or that party. Rather, we need to look at the interests that lie behind this rhetoric and then decode them so that we know what exactly matters in the debate. What matters in the debate is the interest and then this economic stakes rather than simply the terms which are being used by the people. So what are the copyright implications for data scraping and mining? Data scraping and mining, as you all know, is a very fundamental one. All of us may not be doing it, but then whenever we look at a website or whenever a board scrape a lot of information, they do a lot of data is being picked up. And then a lot of applications, including whenever you compare contrast or whenever you run an application that compares prices from different websites or different vendors, it does collect data and then it does put them in together. But then data scraping is so fundamental that it happens on a regular basis done by so many bots that are roaming in the internet. Copyright has got a lot of implications for data scraping and mining and learning, because the whole corpora or the whole corpus of the thing which are put together for machine learning purposes, developing LLMs for applications, will include a lot of copyright works. That copyright works being included might or might not be acknowledged. So when an application or when an LLM is built by using digital copies of the copyrighted works, that still will impact the economic right of the reproduction. So the copyright holder or the one who holds the license, his economic rights will be infringed because he or she or the owner may not be getting anything from it. And the changes in the material can be considered as an adoption. For example, my chapter or my work is being used, or someone else's painting is being used, or someone else's music tunes are being used in the application, and then they are tweaked or then made some changes are there. Whether they slightly changed or fully modified or to what extent the changes happened is a different question, but that could be considered as an adaptation because they are being used as the source raw material. For example, if I take a tune of a famous film composer and then use it in my application or an LLM, and then I make some changes. When the original tune has got guitar, I bring in some other thing like accordion, or I bring in some other instrument. If I replace one instrument with that and then I say tweak it, then that becomes an adaptation to some extent. So research or the text data mining exemptions are available, but then they are not universally applicable. And more importantly, not all activities of researcher and firms are covered by that, because there are some serious limitations in the sense that there is no blanket license or blanket exemption for all activities of research and firms in the name of data scraping and mining for research purposes. We will see some of these in detail later. So what are the real legal gray areas here? Layered protection complexity is there, and that becomes confusing for users and regulators, because copyright protection is a layered protection in the sense that it is not something that could be easily understood or put to practice. Why? Because one, the copyrighted material is available in different formats and then with in way that could be made sense of. For example, digital rights are different from the right to reproduce of a text. Similarly, the right to reproduce itself again is something that varies from context to context, from country to country. That right to reproduce for academic purposes is different from right to reproduce for commercial purposes. And then the availability of digital copies in multiple forms without specific, able to identify the copyright holder or copyright owner is become one more issue. Second problem is that copyright comes in layered protection, in the sense that for what purposes this protection available, to what extent becomes an issue. So the layered protection for different types of materials of the same, this is that for different copies. For example, sound recordings, digital copies, and then multiple audio visuals being made available, particularly in films, the layered protection becomes very difficult. It will be difficult to identify in a film as to whether the music is fully protected by the music composer, or has he licensed it to someone else, or is the producer who is the final owner of the copyrighted material is a question. And then the layered protection also, depending upon the use, depending upon the medium, and depending upon the format, makes things very difficult. Machine learning per se itself in a legal gray zone, because machine learning learns on established data processing and analysis cycle, and then the idea of machine learning itself is not very old. And what is making things all the more difficult is that these powerful models, LLMs, major applications, they get integrated into services of different entities, different organizations, and then they proliferate, they get integrated. So when they are rapidly put to use, there's a lot of gray areas, in the sense that will anyone know, or will any copyright holder know, that what application has used the materials in what format, and then for what purposes, and in which quantity? And the generative AI becoming more and more used in consumer facing applications like Canva or Midjourney, or in different sorts of applications, different ways, or in combination of them. It becomes increased AI, generative AI's visibility being increased. But then this has resulted in a lot of lawsuits being filed against OpenAI, and then by publishers against some of the people who have developed and deployed them, and then some cases by the real copyright holders, who themselves are shocked to find that materials have been used in generative AI applications without their own permission. So dominative scenarios here is that generative AI becoming more and more in user-facing applications, and then generative AI applications like Midjourney, they can use the material, they can use the painting, and then the user can also use the materials available with them to come up with something new. So generative AI as well as user-facing applications being the major developments, they also result in a lot of gray areas for copyright exemptions and applications. Then to simplify matters, we can look at them as continuously deployed and off-the-shelf models. Off-the-shelf models are the models which could be deployed for a different application, but for specific purposes. For example, models in insurance, models in healthcare, models in different educational purposes. Here, they are not like the typical model that needs to be constantly updated in terms of data from other sources. They are not the models that would need constant data from external sources. They would need data, but that would be internal. For example, a health-based AI, once trained, may not need so much of data from external one, because the data which it needs to get trained further and further for analysis would be mostly the data that would be fed to it from the inside the organization, which could be a hospital or a research organization. So these are off-the-shelf models. They have been already fine-tuned, tested, and then aligned for specific purposes. So ChatGPT is different from these models, and then these models again are also proliferating like in any way, right, left, and center. So the problem is that who will really monitor which materials have been used in training when these things are being continuously deployed? So if we understand them as reproduction rights, then European Union's directives deal with them in different ways. We will look at the right to reproduction and the Information Society Directive, and then that is available as a temporary exemption under Article 5 of 1. So this enables technological development because this is a temporary exemption available. But there is also the copyright in the digital single market, or CDSM, of the same European commissions. So there's a tension between them. And then this directive CDSM was brought in 2019. So the question is, Article 2/5 of the 1 of ISD, and then Article 3 and 4 of CDSM, are they really fully compatible? Particularly when it comes to text and data mining exemptions, we are just giving an illustration here. We are not going to the fuller details here. And then research uses exemption is available under Article 3 of CDSM. But again, this is subject to lawful access, and then contracts are being involved here. Then Article 4 of the CDSM gives an option to opt out. So for non-scientific purpose, one can simply opt out of the their reproduction rights. Then there are issues like lack of harmonization between IST and CDSM, and then CDSM is again applicable only within the European Common Market area, or it is not globally applicable. So when Europe tried to link up with the ambitious plan for a single digital market, they came up with a lot of notifications, directives, which they thought will make European market as the single biggest market for digital products, innovation and services. So they were trying to pioneer some sort of directive which would balance the interests of the right holders and then those who build innovations on them. But scientific and research users are also ones which are very major application here. So when it comes to copyright in machine learning, this is a very gray area because the uncertainty affects the research users as seen in earlier. Lawful access terms control research possibility and cost because lawful access again comes with cost and then restrictions in the sense that the right holder may put some restrictions that this could be used only for the purpose of research and not for further commercial development or for commercialization purposes. Then the licensing terms might be available in a very restricted one for the valuable data sets. So the right holder has got the option to license the materials to AI firms. But the problem here is that when they want to give them on licensing, the problem comes when the right holders find that the materials which are already put in archives, they may say that this archival material will be available but not for the public interest purposes, and then they may try to club different type of users as if you are going to use an earlier archive which I claimed earlier as an exempted one for public interest research, it will no longer be available. So they could withdraw it, they could put it into a different category where you need to really go and then ask for some license to use them. And then there are a lot of live online services available, which could be news broadcast, which could be educational broadcast and telecast, which could be a simple podcast, which also uses audiovisual material. The public interest component of them would be there, but then there is a blurred boundary between them in the sense that what is the competitive control, the commercial interest, and then public interest there. And then to what extent the TDM thing will be applicable here is not fully known. Unfortunately, Europeans are getting stuck in this because they pioneered what they call as sui generis database rights, and then the sui database rights is something that's unique to Europe. No other country or no other continent in the world recognizes something called sui generis database rights, and that is really complicated matters. Because for legal purposes, a database is a collection of independent works, data or other materials arranged in a systematic or methodical way and individually accessible by electronics and other means. So once the database is created, that automatically entails the database creator or the database license holder a lot of rights. So Europeans wanted to try with something called sui generis database rights, but in the context of electronic digital products and other things, that has reached a sort of confusing reality to them. So this again getting reflected in the AI development, and then whether the training purposes will be what will be the impact of this STGDR is not clear. So one option would be to withdraw machine learning context under the Article 4 of CSDM. The one could opt out. But this opt out, if done on large scale by different authors by different entities holding copyright, this will reduce the diversity and quality of AI models because ultimately AI models depend upon the availability of large developed data and then other materials for training and other purposes. So when so many of them opt out, stating that my material is not available for this, the AI development models they may be poorer in terms of content or they may not be very rich in terms of diversity of the content. Okay, even if the creator or the one who holds a license is not willing to opt out and still wants to stay okay, mine is available, the individual creator's share is likely to be very minimal because the foundation models have billions of parameters and trained on trillions of tokens. So when so much of them are there, the value or the share of the individual creator's copyrighted material being used will be very minimal. It could be something like not even 0.00002% of that. So when that much minimal is being used, the creator cannot expect too much from them when the share is so minimal. And then this results in the question of policy choices for AI and copyright, particularly in this context of training data. Obligation to disclose training data is good in public interest. But should that be made compulsorily by the policyholders? Because if that is done, there is transparency in development reviews, as everyone will know what are the sources used for training, and then from where they have been taken, and then what sort of materials that went into the building the models. But then there are legal and ethical considerations in the sense that if it is known that much of the material has been trained, has been taken up without any further legal licenses and in an unethical way, in the sense that without the user or the without the copyright holder being authorized, it has been taken by in a way infringing way, or it has been taken from depositories which themselves are in fact violation of the copyright. It is totally illegal and then unethical. The other unethical issue comes when the material is being taken full form, but for the training purposes and then for developing outputs and for other purposes, that material is being mutilated or damaged, or its artistic integrity is being denied, or it's being totally damaged, in the sense that the artistic integrity of a painting or a sculpture or a artwork is being denigrated or mutilated or damaged in one way or other, it affects the moral right of the author. Moral right of the author will be available even if the whole copyright is being assigned. Or copyright ownership is not a precondition for asserting the moral rights of the author. But in training purposes and then when models are being used in AI or being developed, it is a potential possibility. It's a possibility that moral rights could be violated or moral rights could be ignored in the process. So, how can the authors assert their moral rights, particularly when they are not even aware that their material is being used and then also with violation? One solution which has been given is collective licensing. Now, collective licensing is valuable option when some circumstances when I need material, but the only small extracts from different sources. For example, I want to publish a book on cubism, and then I want to illustrate only one or two paintings of a painter. I don't need access to the hundreds of the paintings, or I don't need access to many of the works. I need only one or two to highlight certain things. Then I can negotiate because this is small extract. But I want to reuse it also. So when I want to reuse small extract from different sources or copyrighted materials, I can go for collective licensing. And this is an efficient collective way because then it fulfills the need of the person who wants to use them for a legal purpose and only the extracts, not the full one. And then who holds the right for it? For organizations who want to reuse copyright materials without breaking the law, the collective licensing helps. In the sense that I can still compile, I can still publish, I can create something new by assembling the works of others in a different way, in a small way, and then still I'll be able to do them. And this gives access to rich variety of materials in the sense that I want to pick some sample of a music tune from somewhere else. I want to pick some painting from somewhere else. I want to pick some copyrighted text from somewhere else. I want to pick some audio visual material, but not in its full form. So I want to access only 3 minutes of a popular film song, that to the incoming, the interlude of that. Or I want to access only the first humming voice of a popular film or a music. Or I want to access only the specific notation in a concert or in a song only to that extent. Then I can go for collective licensing mechanism. But the problem here is that collective licensing mechanism again would need negotiations with so many right holders, and it is not something that should be always be tried upon when you are not sure of the real owner. In the sense that if you don't go for collective licensing, if that option is becoming difficult, it is better not to venture into that using too many of the materials from different sources, assuming that since I'm using only very little material from here and there, I'm not violating copyright. That will be lethal in the sense that that could be too damaging because too many people can sue me for that. And so, in the context of AI, this becomes all the more problematic, although there are a lot of legal gray areas over there. One option would be that policy choices for AI and copyright is to promote open source software, open source materials. Further innovation is possible, and there are community contribution improvements that could be recognized and rewarded. So, collective learning for machine learning is a good option because it doesn't put too much of a botheration. It promotes innovation, prevents innovation holdups on account of the lack of machine licensing not available. But the difficulty comes, I need to assemble sufficient rights from different stakeholders, different copyright owners. In the sense that often it will be very difficult to really identify the owner. For example, in case of some works like films, it's a legal gray area in some context as to who exactly holds the rights. And then the right holder may not be available, or right holder might have expired, or the right itself might have been transformed, or might have been gone from one hand to another, or might be available with someone who asserts his or claim, but then I am not sure as to that person is the ultimate right holder or not. And then lot of orphan works, this becomes a major problem because orphan works nobody holds the right, and then even identifying the right holder becomes too problematic. In some specific instances, particularly for films and then for theatrical works, in like drama, who exactly holds the right will be difficult to decipher and then negotiate. And then multiple parties may stake claims. And then how much of the sufficient right I need to really look into assemble becomes problem. In the sense that is it enough I assemble the right only for this purpose, or I assemble the right for BUs or multiple purposes is also an issue. So when I use or when I need access to different types of materials like text, audio, visual, data, and then multimedia resources, it becomes very difficult. So the feasibility issue is something where I need small portions of lots of multimedia works, different works from different sources, from different you know collections. Collective licensing as a mechanism is good, although there are a lot of feasibility issues being involved. Coming to the next point of how do we solve this problem? Don't go for collective licensing, instead levy. In the sense that I levy 2% or 3% of this of the value. And then levies are, we all know, are very small percentages, but then when done in sufficient quantities, they become sizable amounts. So Professor Martin Schönbellen said we can go for levy approach because that will give an equitable remuneration to others. So he came up with this idea in 2023, which has been further developed and written by him, generative AI and author remuneration. And then the available sample here, model here is that EU rental directive as a model. Here the levy is provided by the providers of the generative AI systems. And then the funds that are directed to social and cultural benefits of the collective management organizations. Idea here is to foster and support human literary and artistic work. But the real challenge is that organizing this is very difficult in the sense of, you need to really, someone has to really identify who all will be the ones who will pay the levy, then who will collect them, who will distribute them, and then even to identify cases where the levy is really collectible or is applicable is a major problem. For the simple reason, too many things are happening, too many models are being developed, and then a lot of data is being acquired for or being put to use for training purposes in thousand possible ways. So issues around levy efficiency remain unsolved in the sense that is levy a really efficient way, because there is a whole lot of cost including developing an institutional mechanisms to assess, to collect levy and to distribute them. That is the first point. Then is it really going to be an efficient mechanism if ultimately in the end of the day amount that is collected as levy is not that big or is not that substantial compared to the people to whom they should be distributed to, and compared to the cost of collecting the levy and then identifying the people who will pay the levy? Then If the authors or if the creators are not going to benefit substantially from it, in the sense that what they will ultimately get from the amounts collected as levy is peanuts, or say $10 or $20, an author will get if from an LLM or from a model which has been developed using his or her material, that doesn't make much difference. So litigation also is there as to who will pay and then who will receive and then who will distribute it. So the levy approach is good in theory, but putting that to practice has got lots of implications. One way is to promote open source models, because open source advantage is there in the public interest. And then there is transparency, because open source models can outperform closed AI systems. And then open source applications have been used in past in protocols and then operating systems. And more importantly, the licenses are well defined and then also well recognized in terms of commercial applications. So the common training sources can be easily built upon. Repositories can be governed by open source licensing, for example, Wikipedia and GitHub. And then different source of varieties of licenses are available, like Creative Commons itself makes available various licenses for different purposes. So it is easy to identify the purpose and then tailor make the license and then choose it and then make it applicable there. The sense that open source licensing mechanism is also easy to negotiate with, and then we know the Creative Commons licensing, and then there are so many licensing firms available. Since there is a huge licensing models available, and then there have been a lot of experience for the last 2.5 decades on using open source models licensing for different purposes. This is a viable option where the rigidities of copyright can be removed, and then a lot of flexibility is also being made available. So the legal technical opacity in the machine learning is also there, and then unlicensed models always come with a lot of risk. So better to move towards fully licensed AI copyright, where you know that everything is clear in terms of legal licensing and then legal rights and then responsibilities. So irrespective of the available exceptions, better to move towards a fully licensed copyright environment, so that both the persons who run them, who bought them, as well as who developed them, know that their licensing fulfill the copyright norms, and then they are crystal clear as to what are they dealing with. But then the question will be where to obtain the right license, and then to identify the right license, and then under what conditions. And then the global deployment of AI and ML models versus the national variations in terms of copyright exemptions, licenses, and then the organization that deal with them makes it very difficult to deal with, or they make things quite complex. One way to look at this issue is that there are a lot of public benefit in using copyright works. But we really do not know as to what exactly are the public benefit when they are used in AI training, because the AI training itself is not even 2.5 or 3 decades old by now. The current copyright solutions are again controlled by major holders and large firms, which we saw in the previous session. An alternative purpose solution that has been proposed is that to treat the machine learning itself as a general purpose technology. General purpose technology is a technology that could further promote innovation, and where it can go much beyond that, like steam engine, electricity, internet. These are good examples of general purpose technology where they not only value addition, but then they cause societal revolutions, they bring in economic transformation, societal transformation as well. So how can copyright law deal with a general purpose technology if we develop machine learning as or identify them as a general purpose technology? So the novelty of technology's ramification is more than copying and reproduction. But we need to balance market entry costs, market entry benefits, open source innovation, and then the creative remuneration, creator remuneration. And then we also need to really identify these tensions when we talk of public benefit that would derive from copyright works, and then when we apply open source licensing for in copyright AI training. So with all these things coming together, we will go to the idea of generative AI and copyright in the next session, where we will look at the specific issues that need to be addressed in copyright, generative AI and copyright interface.